Good morning. We are going to discuss the role of police under criminal law. To begin with the discussion, it is necessary to know how the criminal justice system is developed in our country. Man is a social being. He never wants to live in isolation, but by his selfish nature, he has always committed disturbances, wrongs, and violence against his fellow beings who live in that society. In early primitive societies, the aggrieved person had no means for redressing his injury or damage against the wrongdoer except private vengeance and self-help, and in some later stage, the payment of compensation to the victim by the wrongdoer was also allowed. This type of justice remained private in nature till the modern state came into existence. In course of time, the state exerted its authority and took upon itself the responsibility of administering justice and punishing the wrongdoer using its force whenever necessary. This stage shows that there was a transformation of private justice to public justice through the agency of the state. Thus, it is apparently clear that the modern administration of justice owes its origin and growth to the gradual evolution of the state and its political power. With the growth of the state's power, private vengeance and self-help were substituted by the administration of criminal justice and civil justice. Secondly, we also ought to know what are the laws which constitute our criminal laws. With this, we have the role of police is confined to our criminal laws. Our Indian criminal laws cover the Indian Penal Code 1860 together with other penal laws like the Preventive Detection Act 1950, the Maintenance of Internal Security Act 1971, the Prevention of Food Adulteration Act 1954, the Protection of Civil Rights Act 1955, the Dowry Prohibition Act 1961, the Unlawful Activities Prevention Act 1967, the Prevention of Seditious Meeting Act 1911, the Armed Forces Special Power Act 1958, etc. constitute our substantive criminal laws. Substantive criminal laws define offences and prescribe punishment for the same. These substantive criminal laws are administered by the procedural criminal law. Obviously, in absence of procedural law, the substantive criminal law by its very nature cannot be self-operative. The work of administration of criminal justice is carried out by different agencies of the state like police, prosecutors, advocates, judges, functionaries in the correctional services and jails. Among them, the police play a very important role, and for academic study, some important provisions of Criminal Procedure Code under which the duties, powers and responsibilities of the police are to be discussed. How arrest is made? Section 41 CRPC empowers any police officer to arrest without warrant any person who has been concerned in any cognizable offence or against whom a reasonable complaint has been made or credible information has been received or a reasonable suspicion exists. Arrest by private person. Under section 43 CRPC, private person may also arrest another person. If the person commits a non-bailable offense and a cognizable offense in his presence or any proclaimed offender without delay. However, the arrested person is to be handed over to the police immediately. The law also provides that for the arrest of a woman, a female police constable shall be accompanied, and no women shall be arrested after sunset and before sunrise without the permission of the magistrate first class of the local jurisdiction where arrest is to be made. Further, Section 50 CRPC provides mandatory duties for the police to inform the grounds of arrest and the right to bail to the arrested person. Examination of the arrested person by a medical practitioner at the request of the police officer and at the request of the arrested person are also provided under Sections 53, 54 and 54A CRPC. Under Section 57 CRPC, if any arrested person is not discharged by the police, he is to be forwarded within 24 hours to the concerned magistrate. In case the offender has been refused bail and if the magistrate remands for further police custody or the judicial custody as the case may be, the accused may be detained for the specific period and the arrested person should be produced from the custody. In spite of having so many rules for arrest and detention, there have been allegations of torture and inhuman treatments, outraging modesty of women and causing disappearance of arrestees without handing over them to the nearest police stations, with least possible delay in defiance of law. Therefore, arrest memo has become an important document to be prepared and issued to the arrestee at the time of arrest by the arresting authority. In a landmark decision which is reported in the case of D.K. Basu versus State of West Bengal, year 1997, Supreme Court 610, the Supreme Court of India declared the law of arrest memo in order to protect the right to life or personal liberty guaranteed by Articles 21 and 22 of the Constitution of India. The idea behind the compulsory preparation of an arrest memo is that creating awareness about the rights of arrestee would be a step in the right direction to control the evil of custodial crime and bring in transparency and accountability. The law on arrest memo is a judicial law to be observed while arresting a person in supplement to what is provided in Criminal Procedure Code of India. The Apex Court declared certain mandatory obligations to be followed by the police and other arresting, detaining authorities till legal provisions are made in that behalf as preventive measures. We have some provisions. Let me explain one by one. The police personnel carrying out the arrest and handling the interrogation of the arrestee should bear visible and clear identification and a name tags with their designations. The police officer carrying out the arrest of the arrestee shall prepare a memo of arrest at the time of arrest, and such memo shall be attested by at least one witness who may be either a member of the family of the arrestee or a responsible person of the locality from where the arrest is made. A person who has been arrested or detained or is being held in custody in a police station or interrogation center or other lockup shall be entitled to have one friend or relative or other person knowing to him or having interest in his welfare being informed as soon as practicable that he has been arrested and is being detained at a particular place unless the attesting witness of the memo of arrest is himself such a friend or a relative of the arrestee. The time, place of arrest and the venue of custody of an arrestee must be notified by the police where the next friend or relative of the arrestee lives outside the district or town through the legal aid organizations in the district and the police station of the area concerned, telegraphically within a period of 8 to 12 hours after the arrest. The person arrested must be made aware of this right to have someone informed of his arrest or detention as soon as he is put under arrest or is detained. An entry must be made in the diary at the place of detention regarding the arrest of the person, which shall also disclose the name of the next friend of the person who has been informed of the arrest and the names of the particulars of the police officials in whose custody the arrestee is. The arrestee should, when he so request, be also examined at the time of his arrest, and the major and the minor injuries, if any, present on his body must be recorded at that time. The inspection memo must be signed both by the arrestee and the police officer affecting the arrest, and its copy provided to the arrestee. The arrestee should be subjected to medical examination every 48 hours during his detention in custody by a doctor on a panel of approved doctors appointed by Director Health Services of the concerned state or union territory. Copies of all documents, including the memo of arrest referred to above, should be sent to the magistrate for his record. The arrestee must be allowed to meet his lawyer during interrogation, though not throughout the interrogation. The last but not the least, a police control room should be provided at all district and state headquarters, where information regarding arrest and the place of custody of the arrestee shall be communicated by the officer causing the arrest within 12 hours of effecting the arrest, and at the police control room it should be displayed on conspicuous board. Failure to comply with the requirements herein above mentioned shall, apart from rendering the concerned official liable for departmental action, also render him liable to be punished for contempt of court, and the proceedings for contempt of court may be instituted in any high court of the country having territorial jurisdiction over the matter. Nowadays, most of the agitations or strikes are carried out by the student organizations, government employees, industrial workers, professional groups, employees of the autonomous bodies, JSC of the voluntary organizations, and political parties, particularly the opposition to the ruling party, by doing violent activities and destroying the lives and the properties of the public. In such situation, the police have to play a very important role as machinery of the state to maintain public order and tranquility according to law. Under section 129 CRPC, any officer in charge of police station or a police officer not below the rank of sub-inspector may command to disperse any unlawful assembly or assembly of 5 or more persons likely to cause a disturbance of the public peace. If upon being so commanded, such assembly does not disperse, any police officer referred to above may proceed to disperse it by force and may require the assistance of any male person for the purpose of dispersing it, and may arrest and confine the persons forming part of the assembly, and they may be punished according to law. Next, the most important for initiating a criminal trial is the submission of charge sheet. Under section 173 CRPC, the law provides that every investigation shall be completed without unnecessary delay. This completion report of the police is also known as charge sheet. The court also held that inordinate delay in submitting final report, that is charge sheet, may lead to the grievance that the investigation is carried on unfairly or with some ulterior motive. 7 years of delay was held a good ground for setting aside the order of conviction. Mention may be made that the police was quick in response in submitting charge sheet in the recent Delhi gang rape case, which involves rape and murder that occurred on 16 December 2012 in Munirka, a neighborhood located in the southern part of Delhi, when a 23-year-old female physiotherapy intern was beaten and gang raped in a bus which she was traveling with her male companion. There were 6 others in the bus, including the driver, who all raped the women. The woman died from her injuries 13 days later while undergoing emergency treatment in Singapore. The incident generated widespread national and international coverage and was condemned by various women's groups both in India and abroad. All the accused were arrested and charged with sexual assault and murder. The accused driver Ram Singh died in police custody on 11 March 2013 in the Tihar jail. The juvenile was convicted of rape and murder and given the maximum sentence of 3 years imprisonment in a reform facility. In another gang rape case which was happened in the state of Manipur, in the case of state of Manipur versus Hrl&Cj and the 3 others under Sessions Trial Case number 8 of 2012, Manipur West. This case is notoriously known as Umoro case. We have discussed in the foregoing paragraphs about the role of police, their powers, duties and responsibilities in the administration of criminal justice system. Without the active participation of the civil police, it is impossible for the state to maintain law and order. Since the beginning of the commission of a crime till the accused is released on bail or discharged from the alleged offences, or the accused is sent to jail before or after trial, they are concerned in all stages. Thus, the service of the civil police is around the clock. However, police become a much misunderstood force when their action gets limited by law, contrary to the natural expectations of the people. There is therefore immediate need to examine the procedural laws and allied regulations for modifying them to enable police response to conform to public expectations consistent with the resources potential of the police. On the other hand, the cooperation from the public is also highly essential.